This program is a presentation of UCTV for educational and non-commercial use only.
Well, it's certainly my honor and privilege to have the opportunity to chat with you in this format, and I'd like to give you my personal thanks that you're doing it. Today is the 24th anniversary of your confirmation by unanimous Senate vote as an Associate Justice of the Supreme Court. So you've been there almost a quarter century. How would you characterize the role of the court in American society now that you've been a part of it?
Whoa. I don't think it's changed any over that period, and I think it's a highly respected institution. It was when I came, and I don't think I've destroyed it. I've been impressed that even when we come out with opinions that are highly unpopular or even highly what should I say? Emotion-raising, the people accept them as they should. The case that comes most to mind is the election case, Bush versus Gore. Nobody on the court liked to wade into that controversy, and there was no way the court was going to come out more popular than when it went in, no matter which way it came out. But there was certainly no way we could turn down the petition for certiorari. What are you going to say? The case isn't important enough to take? And I think that the public ultimately realized, even those who felt passionately that it should have come out the other way, that we had to take the case, and I think the court's reputation survived, which, after all, is why it has its reputation. I mean, you don't have it to put it up on a shelf and admire it. You have it precisely so that when there comes a time that difficult decisions like that have to be made, it's a sort of armor that enables the decisions to have the kind of public acceptance that they ought to have. I was very, very proud of the way the court's reputation survived that, even though there are a lot of people today probably still mad about it. So I'd say it's one of the most respected institutions in American life.
Justice Robert Jackson once said, I think in perhaps the last lecture he gave before his death, that the Supreme Court was not only a law court, but the apex of a branch of government. Is the fact that the court is at the top of a coordinate branch of the federal government shape, or should it shape, our notions of constitutional interpretation? Or is it purely a law court?
Well, it's, you know, any appellate court does more than decide the case in front of it. In fact, that's to my mind, the least important thing that the court does. Any appellate court shapes the law, which is why appellate judges ask hypothetical questions, you know, which lawyers don't like. But the reason you ask them is because, frankly, sir or madam, I don't care whether your client wins or loses this case. I am not about to give victory to a seemingly deserving party in this one case at the cost of causing injustice in hundreds of cases down the road. So the primary role of an appellate court, and especially that appellate court which is at the apex, is to decide cases on grounds, on bases that will produce justice overall in the long haul. And the opinions have to be clear enough that the lower courts can follow them. And it's one reason I do not like totality of the circumstances tests, which we occasionally use. It gives no guidance whatever to the lower courts, and therefore does not lay a sound foundation for justice.
Thinking about the court as an institution, we actually had a brief conversation at lunch about televising arguments before the Supreme Court, and I wonder if you'd share some of your thoughts about the wisdom or lack of wisdom of allowing cameras into the courtroom.
I was in favor of cameras when I first arrived. That's one of the perhaps few things on which I've changed. Over the years, I've come to believe it's a bad idea. The argument usually made in favor of it is, we want to educate the American people concerning the court. Now, if I really thought that it would educate the American people, I would remain in favor of it. But I've come to realize that it really will not. If the American people sat down gavel to gavel, if they watched the entire feed of our cases, yes, they would learn what the court is like. They would come to realize that we're not spending most of our time speculating about whether there ought to be a right to suicide, whether there ought to be a right to this or that, whether there ought to be and therefore is, but rather that in fact we spend most of our time on pretty dull, very legal stuff like the Internal Revenue Code, the Bankruptcy Code, and no one would ever again come up to me and say, as, believe it or not, people frequently do, why, Justice Scalia, why do you have to be a lawyer to be on the Supreme Court? The Constitution doesn't say so. No, if you think we're contemplating our navel most of the time, contemplating grandiose philosophical principles about whether this, that, or the other right ought to exist, sure, you don't have to be a lawyer. But in fact, most of the time we're doing law. And so they would be educated. But for every 10 people who watched us gavel to gavel, there would be 10,000 who would see 30-second takeouts that would appear on the nightly network news. There's no way to stop that. And I guarantee you that those takeouts will not be characteristic of what we do. They will be uncharacteristic. It will be, man bites dog. So why should I be in favor of something that I think will distort the public perception of the court?
Do you think it would...
Besides which, I must admit, I have something of an old-fashioned notion that familiarity breeds contempt. I think there's something to the fact that the institution is somewhat remote, and it isn't coming into everybody's living room every night. Anyway.
Do you think it would alter the way that counsel would argue before the court?
I think, sure, it certainly would.
Do you think it would make it better or worse?
I think make it worse. I think they'd be grandstanding. I think they'd be showing off. I don't want to see counsel show off. Just the facts,
Just the facts, ma'am.
Right.
As Sergeant Webb said in Dragnet. Some people propose, this has been current in academia mostly, and so one wonders whether it'll ever have any traction in the real world. But some people in academia have proposed that the justices' terms ought to be limited. And there have been various inventive proposals as to how that might be done without amending the Constitution's guarantee of life tenure. However it's done, do you think that's a good or a bad idea?
Well, so long as you grandfather,
Oh, we'll stipulate to that. Your grandfather did.
It has always seemed to me that this is a solution in search of a problem. What is the problem? Are there too many doddering justices on the court? in the time I've been there, there's nobody who stayed around longer than ought to have been, and they were all still hitting on all cylinders when they left. Brennan could have stayed around longer. Lewis Powell could have. Certainly Sanders could have. What is the problem? The problem is that presidents don't get enough appointments. Is that the problem? That you know, Jimmy Carter had none, and what is the problem?
I'm not sure there is one.
Unless it's the age of the justices, I do not. Either that or the fact you want every president to have a certain number of appointments. Unless it's one or the other of those two things, I don't see what it accomplishes. Or maybe there's a third. I don't. Well, what's a third? Maybe you want. I think there's a great advantage in having a huge time span. I mean, when I came on the court, there was someone who had been appointed by Dwight Eisenhower. I mean, Bill Brennan had been appointed by Eisenhower. The court makes, in its most important aspect, its constitutional decisions, it makes a judgment for, a society over time. And I think there's a lot to be said for having sitting on that court men and women who represent the society over time, and not just the current society. I mean, the current society expresses its wishes through the legislature. There's no doubt about what that society wants. But if you do believe that a constitution places some limits on the current society in light of the society over time, you, it seems to me, would prefer a court that represents the society over time. No.
You're well known for what has been variously characterized as being a textualist in constitutional interpretation. Some characterize you as an originalist. Let's sharpen that a bit and suggest that originalism is the search for the original meaning of provisions of the Constitution. And I believe at one point you may have defended your methodology because you believe in an enduring Constitution, as you put it, rather than an evolving Constitution. I hope I'm not quoting you incorrectly.
Very well put.
Well, but I want to hear more from you. I wonder if you could explain what you mean by the concept of an enduring Constitution.
Well, look, in its most important aspects, most of which are in the Bill of Rights, I suppose, the Constitution tells the current society that it cannot do what it wants to do. It is a decision that the society has made that in order to take certain actions, you need the extraordinary effort that it takes to amend the Constitution. Now, if you give to those many provisions of the Constitution that are necessarily broad, such as due process of law, cruel and unusual punishments, equal protection of the laws, if you give them an evolving meaning so that they have whatever meaning the current society thinks they ought to have, they are no limitation on the current society at all. And the whole purpose of them is eliminate. If the cruel and unusual punishments clause simply means that today's society should not do anything which it considers cruel and unusual, I mean, it means nothing except to thine own self be true. You know, we think thumbscrews are bad, but you know, if you think thumbscrews are okay, God bless you. It's not cruel and unusual if you don't think it's cruel and unusual. So, you know, I interpret it the way it was understood by the society at the time. And if you don't, now, this doesn't mean that there aren't new things that come up. Of course you have to apply the text to new phenomena, which the founding generation didn't even know about. But as to the extant phenomena, whether the death penalty is cruel and unusual, whoever voted to make it impossible to have the death penalty, or to make it impossible, for that matter, to have the death penalty for anyone younger than 21 years of age? Whoever voted for that? Nobody. you make out of the Constitution something that it was never meant to be. And it's all done by a Supreme Court, which is probably of our political institutions the one least capable of understanding what the current society really wants. We're not supposed to know what the current society wants. That's not how we're supposed to vote. So why you're going to entrust this institution with keeping the Constitution up to date, if that's what you want to do, which it shouldn't be. You know, even if that were the object, you've picked the worst institution. Do it the way England does it. If you want to keep make nothing of the Constitution. That is to say, the English Constitution is whatever Parliament says. There's no such thing as a law of Parliament that violates the Constitution. Parliament is the trustee of the Constitution. Well, if you believe in the evolving Constitution, that's what we ought to have here. Marbury versus Madison assumes that what the Supreme Court is doing is lawyers' work, not evolutionists' work. Anyway, I go off for another half hour.
No, I'm sure you got it.